25000876, the people of the state of Michigan versus Tamela Peterson.
Thank you. Good afternoon, Your Honor. Assistant Attorney General Chris Kessel for the people.
Good morning. Good afternoon, Your Honor. Gerald Gleason on behalf of Ms. Peterson, who's approaching and standing to my left.
All right, you can come up and stand at the podium with your attorney. State your name.
Tamela Peterson.
Today was the date and time that the court had scheduled defendant's motion to remove the home confinement component of her bond conditions. We did have an opportunity to discuss the motion and some additional issues that have come to light on this case in chambers prior to having the case called. It's my understanding that you would still want the court to consider a request as outlined in your motion, but for some change in circumstances.
That's a true statement, Your Honor, yes. And I think we can withdraw the motion pending the preliminary examination. So I think we can take the motion off the court's calendar for the time being.
All right, so you are withdrawing the motion at this point. No decision is being made as to what was filed. I did not receive a formal written objection to the motion before today's date, although I have a better understanding of why, and I will allow the prosecutor to make whatever record he deems appropriate as it relates to bond at this time.
Sure, Judge. Without going into too much detail, between last week and this week, the people have come into some information that it appears the defendant has been violating her bond, whether she was doing that for several weeks or for several months. I think it's very clear that that's what's been going on. The people came into that information literally as I was drafting a response to this motion. As the information came in, I dealt with it as best that I could. I was able to provide Mr. Gleason with that information this afternoon, before we came into the court. The people believe that the defendant has violated her bond, specifically with respect to the possession of firearms condition. That, going along with a number of other violations that this court is aware has taken place, gives the people real concern about this defendant's ability to continue to stay out on bond in any capacity. So that's the people's position right now. Obviously, we objected to the motion, and we'll go from there on a full bond hearing when the court is pleased by that action.
All right, so this allegation that's been presented to the court today regarding a potential violation of the bond conditions as it relates to the provision that she is prohibited from having in her possession any firearms or weapons. Although I understand she has just received notice, she has received notice at this point that there is an allegation that would be pending that needs to be addressed. Is that a fair statement?
That's a fair statement, Your Honor. I think, to put a finer point on it, I think the time frame for the allegation is between the time of her arraignment in June of this year, if I understand the...
I don't know if I'd go that far, Judge. I think there might be room for argument as to when this particular bond violation ceased. But it seems for sure that it was going on from when she was arraigned until early June of this year.
Candidly, Your Honor, I'm not prepared, having received these just now, I'm not prepared to contest them. Now, obviously, we disagree and would plead not guilty to any bond violation allegation. And so what I'm asking the court to do is set it for a hearing, and in the interim period, if the court wants to amend the bond, that's within the court's purview. I'd ask that she be allowed to remain outside the jail pending the hearing so that I can gather the witnesses that would be relevant to proving to the court that the allegation made by the Attorney General today is false.
All right, and I think that that's also a fair recitation of the conversation that was had on this issue. Obviously, Ms. Peterson, anytime there's an allegation that you are not compliant with the bond condition, the potential outcome for you could be a modification or a revocation of your bond, which is obviously a very significant sanction. And for that reason, you're entitled to have a hearing if you're contesting the allegation. I know that the people feel strongly that they are in a position to proceed, could have potentially even presented some information today. However, because you're entitled to have a hearing and your attorney has placed on the record a not guilty plea on your behalf and a request for a hearing, I think it is prudent to address the allegation in that manner. I could make changes to the bond today, including revocation, if I felt that the allegations were so serious that immediate action has to be taken. I do feel these allegations are very serious. There will be a hearing so that we can address them. But in the interim, knowing that you are already partially confined to home, we had been making some modifications so that you could conduct some affairs outside of the home with prior approval from pretrial services until we are able to resolve this issue that's now outstanding regarding the bond compliance allegation that's been put forth today. I am going to continue the $2 million bond that you posted, but I am going to return to the very strict adherence that you had originally for home confinement. You will still have those same caveats for medical, legal. I want to make sure that I have the exact same ones that are articulated on the record. Medical, legal,
My recollection are the original ones were that if she had medical issues, she could leave the house with prior notice to pretrial services, and if she was going to meet with us, she could come directly to our office.
in court, any court related.
In court,
I'm
yes.
sorry. So those are the caveats that I recall. They require prior approval in that if you have appointments related to the case with your attorney, medical appointments. I believe that there was employment though, but it could not contain anything related to the business that was at issue. I'm sorry, I was not.
I think it was just, Judge, anything involving a business that owned or operated hyperbaric chambers.
Correct.
Okay. Attorney, medical, court. That was it. So those are the ones that will be back in place. Same operation for pretrial service supervision. If you have to get approval to leave the house, it has to be done in the requirements that are outlined by pretrial services, and all conditions, other conditions, remain in place in full effect. We had discussed the potential for when this hearing would be set. I think we need some additional time to flesh that out, but it will be quickly. But we were discussing setting it either before or immediately following the examination dates that are already set. And I will be allowing my clerk to reach out to the two of you to discuss the date and time that this hearing will take place. I expect any issues that are potentially going to be alleged regarding violations of bond to be reported immediately so that we can address them, so that when we are going to proceed to this particular issue and have the hearing for the court to determine if a violation of bond occurred, we can address anything that is out there that would be pertinent to a court's decision to modify or revoke bond if there's the evidence that supports it. Is there anything else we need to place on the record today?
No, Your Honor. No, Your Honor.
Nothing from the people, thank
All
you.
right. I do want your client to get a copy of the amended pretrial release order before she leaves.
Up front.
And then to circle back with her case manager to ensure that she has all of the information she needs about the conditions of bond.
Understood, Your Honor.
Thank you.
Good afternoon. Have a good afternoon.
Thank you.
Thank you.